Thank you for that introduction, Professor Vessels. Good evening. My name is Maxwell Boltinghouse, as I was introduced, and I'm here to talk to you about something that I feel is of the utmost importance and something that we, as advocates and individuals who experience work in the criminal defense realm as well as the prosecution and just work in the criminal realm in general, need to be aware of because they can have significant negative impacts upon the individual. And that is pretrial release, pretrial services, and we need to understand this so that way going forward, we don't fall into the trap that not protecting the individual and not being aware of the conditions that can be required with pretrial release can lead us to a wolf in sheep's clothing, waiting to prey upon the individuals that are participants in the program. In 1987, the United States Supreme Court decided Solner versus the United States. And in that case, the United States Supreme Court said unequivocally that liberty prior to trial is the norm and that pretrial detention should be a carefully limited exception. Associated with pretrial detention and alleviate the costs and the problems that are caused from offenders who are simply stuck in detention because they cannot afford to post bail. And now, this may not be an issue that is new to you. As Mr. Jensen talked about earlier, bond is a very important issue. And even in circumstances in modern day society and in the mainstream, the rest of us, Colorado included, are left on this sort of county-to-county basis, meaning that if you face a bond hearing in Arapahoe County versus one in Denver, the repercussions and the outcome. You can see higher bails set in certain counties as opposed to others, conditions placed on bond in certain counties that would not be placed otherwise. So if you're sitting there wondering, as I am, is there any sort of guidelines to cover these pretrial services program, to cover how they're administered, to cover the conditions that are given to individuals, and how bond is set? We do have some relief. And in 2002, the ABA codified as a black letter standard their view on what pretrial release and pretrial services should be doing, the purpose of the program, and the requirements that should be placed upon it. And when that was published in 2007 under the third edition of the pretrial release standards, it was stated that the purpose and the point of pretrial release is to preserve the due process of the accused, to secure the defendant for trial, to do so by the least restrictive means, and to do so using an evidence-based approach. That evidence-based approach was going to be done by understanding the nature of the charge, understanding the nature surrounding the case, and through understanding the defendant. And if this sounds similar and this sounds familiar, it's because it's something that was implemented here in Colorado just a little bit later. When in 2013, Governor Hickenlooper signed into law House Bill 131236, a bill that mirrors in a lot of ways very similar guidelines and statutes set forth by the ABA. This bill, which was signed into law, sets forth that a defendant is presumed to be eligible for the least restrictive form of release, that determination is to be made after an evidence-based approach, that determination is supposed to be made with appropriate considerations for the defendant's circumstances, their situation, and whether or not they're actually eligible for a monetary bond should be something that is not a question, because under this law, everyone is presumed to be under the least restrictive form, meaning a PR bond, unless something is shown to convert that or to go against that. So we have to ask ourselves, is this occurring? Is this happening? What is actually happening? And how is this determination on bond and on bail being made? And the way that it's being made here in Colorado was made after the Pretrial Justice Institute and the Justice for All Institute made a determination and came up with the CPAT. They developed this in results to studies that they had done that showed that pretrial detention leads to recidivism, pretrial detention leads to disruption of family relationships, pretrial detention leads to disruption in employment. It leads to negative circumstances and effects on the individual. It leads to harsher sentences. The person charged, if they're detained prior to trial, is more likely to plead guilty. So there needed to be a way to determine the proper way of analyzing people and a proper way of assessing risks and likelihood that they will show up for court. And the way that that was done is with the CPAT, the Colorado Pretrial Assessment Tool. And I stress tool because it really is just that. It's not the end-all be-all. It's not the determining factor. And it shouldn't be the only thing that someone uses to determine whether or not bail should be set and what conditions should be placed upon that. We as people working in the criminal justice system, and we as individuals who may at some point in time face a bond hearing or face conditions on bond, need to be aware of what this does and how it evaluates individuals. And what this test does is it takes 12 factors, things such as, do you own a phone? Are you renting or do you own your own home? Do you contribute to residential payments? Do you have mental health conditions? Have you been receiving substance abuse, counseling? Do you have active warrants? Are you under current supervision? All of these factors about a person's history are used to determine who that person is going forward and who that person will be during the trial and the risk they present to society. And I want to get back to the idea that this is just a tool, because too often than not, and more often than not in my experience, although Arapahoe does a different system than the CPAT, we can see that these pretrial assessment tools are taken as the end-all be-all. They're taken as a determining factor of who that individual is. And some problems arise with that, because even in the scoring of the CPAT, if something is unknown, it's weighed against the defendant, it's weighed against the individual, and it's to their harm. Because if that risk assessment comes back, it divides people into one of four categories based on their risk. And if it comes back with too high of a score, that person's bail can be increased, conditions can be added onto their bond, and they can face a harder road through to trial even before a scintilla of evidence has been presented against them or before their presumption of innocence is left. It is of the utmost importance to understand that the effect that a tool like this can have when put in the hands of prosecuting attorneys, when put in the hands of judges, when put in the hands of defense counsel, and is not given a second look. So we must ask ourselves, if this can affect bond and this can affect the conditions placed upon bond, how does it affect that? How does it affect the conditions? And with that in mind, I want to talk a little bit about the conditions that can be put on a bond. And those can come in a variety of circumstances, and they all restrict an individual's liberty. They all go back and forth. But what we see here are four pretty typical categories of conditions on bond. Phone check-ins, physical check-ins, monitored sobriety, or GPS or scram monitoring. All present varying different degrees of restriction on one's liberty. All present different difficulties and unique difficulties for an individual who may be facing those. Now, it should be noted that these conditions on bond are also very important too, because failure to comply with these conditions doesn't result in a slap on the wrist. It can result in pretrial detention and bond forfeiture, which are very severe circumstances for an individual already facing a very traumatic event. A person who's already probably wondering whether or not they should be pleading because they're in custody. A person who's already got their back up against a wall. So it's important to understand that how these conditions can affect an individual and how they can create hurdles and difficulties going forward. Let's look at the first one, phone check-ins. Something that you and I would probably take for granted and think is just really innocuous. Making a phone call into a pretrial service officer. It's kind of difficult, however, when you don't have access to a phone. And as many of the clients that I do see come across, and many of the people that I run into on a day-to-day basis, do not live a stable lifestyle. They're coming across our desk for a reason. They're indigent. They have things going on in their lives that make it difficult for them. And as such, quite commonly, phone numbers are not something that a lot of people have, or at least consistently have. And so it can place significant difficulties on an individual who may be a transient, who may be indigent, who may not have a stable home environment to call in and meet this condition of bond. But let's step it up another notch. Let's look at physical check-ins and see how those can provide further problems for an indigent client, for a transient client, for anybody who has difficulties in their lives. Let's say you don't have steady transport, you're forced to use public transit. Let's say you don't have a valid driver's license. You're at the whim of a public transit system or at the whim of others to make sure that your bond conditions are met. That's a difficult choice to make and a difficult decision to put someone in. Because if it comes between making sure that you have reliable transport and being able to make it to a bond meeting, or maybe going to your job, which is dependent on scheduling, which due to the transport may not allow you to even get to your pretrial services meeting on time, that's a choice that no one should have to make. And it's a difficult position to put anyone in, let alone someone who is already facing charges and has yet to have anything proven against them. Understanding the difficulties that these conditions can put on an individual are of the utmost importance. And with that, I want to go into monitored sobriety, probably the most frequent type of condition to be put on bond, and probably the most frequently misused condition on bond. When looking at somebody needs to be monitored on sobriety, you must take into account the condition of that client, whether or not the circumstances actually warrant a view of their sobriety, and whether or not that invasion of privacy is warranted, and if they can actually afford it. Because unlike probation, unlike a lot of other court services, and unlike even the representation of the public defender's office, pretrial services comes at a cost. It comes at a cost that cannot be waived by indigency. It comes at a cost that does not have vouchers for it. So we're in a position. A client is facing monitored sobriety, and the question is, do I pay for my monitored sobriety and go forward? Or do I buy food and risk bond forfeiture and risk bond revocation and potential pretrial detention? These questions are important, and they're questions that no one should ever have to ask or be put in that situation. These are difficult issues to deal with, and it's a juggling act of importance on either side. We need to preserve public safety, we need to ensure defendants' due process, and we need to ensure that the judicial process goes forward with integrity. And the only way to do that is to assure people for trial. But when you're over-conditioning people, you're making people make hard choices about their life or complying with court orders. No one is in a good situation, and it defeats the purpose of pretrial release and pretrial services because it sets people up for failure. And that's what we need to ask ourselves when we're imposing these conditions, when we're imposing something like GPS monitoring that's done at the cost of the defendant, when we're proposing monitored sobriety, when we're asking somebody to come in and check in physically. What are we actually asking that individual? Are we straying into territory where overconditioning is becoming a wolf in sheep's clothing and something with admirable goals and admirable ambitions and a way to do it is being perverted, is being subverted, is being changed because we're not keeping a watchful eye? So what we have to ask ourselves going forward, and what I'm going to ask each and every one of you in this room to do going forward, is to not sit idly by. When a condition on bond is proposed, or you're facing a bond condition, or you're facing a bail hearing, ask yourself, what does that condition mean for myself, or what does it mean for my client? What does it mean for the defendant that I'm asking this condition be imposed upon? Ask them clearly and ask them frankly, because the answers to those questions determine whether or not we're setting someone up for failure, whether or not we're setting someone up for loss, whether or not we're setting someone up to go into pretrial detention and end up with the effects that we have seen this entire time: increased recidivism, overcrowding of jails, and setting people up for failure with regard to bond. These are real problems, and the only way to address them is to clearly understand how they're happening and to communicate, to educate, and to advocate for your client, to advocate for yourself, and to educate and communicate with opposing counsel and those that are making these decisions. Because ultimately, if that communication does not occur, if that education does not occur, if we do not make people aware of this problem and how it's happening, it will never be corrected, and we can never achieve change on a large macro scale. To combat this problem, it needs to be done on an individual basis, on a case-by-case basis, on a client-by-client basis, and a person-by-person basis. It's only through individual advocacy do we prevent a system with admirable goals from becoming the wolf in sheep's clothing, and that's only the way that we can combat this problem and go forward on the right foot and achieve the goals that were set out in 1987 in the Supreme Court ruling, that liberty is the norm, and pretrial detention and restrictions on that liberty are a carefully limited exception. Thank you.